Okay, thank you, Heavenly Father, for allowing us to meet here today in your name. Please open up our minds and our hearts to what you would have us to know. We ask this through your Son, Yahushua. Amen. Do we have any announcements? I've got something that was emailed to me that I thought was interesting, if nothing else. It's pretty short. It's 9 pages. It should take about an hour. But no, not really. The subject is history. And this one's been around for a while, but it's interesting. I don't know if the people have heard it or they haven't. But look what happens to a president when a president gets elected in a year that ends in a 0. Notice it goes in a 20-year increment. In 1840, William Henry Harrison died in office. 1860, Abraham Lincoln assassinated. 1880, James A. Garfield assassinated. 1900, William McKinley assassinated. 1920, Warren G. Harding died in office. 1940, Franklin D. Roosevelt died in office. 1960, John F. Kennedy assassinated. And in 1980, Ronald Reagan survived an assassin's attempt. And in 2000, George W. Bush, we just got a whole bunch of question marks there. And to think we had 2 guys fighting it out in the courts to be the one elected in the 2000. You might also be interested in this. Have a history teacher explain this, if they can. Abraham Lincoln was elected in Congress in 1846. John F. Kennedy was elected in Congress in 1946. Abe Lincoln was elected president in 1860. John F. Kennedy was elected president in 1960. Both were particularly concerned with civil rights. Both wives lost their children while living in the White House. Both presidents were shot on a Friday. Both presidents were shot in the head. Now it really gets weird. Lincoln's secretary was named Kennedy. Kennedy's secretary was named Lincoln. Both were assassinated by Southerners. Both were succeeded by Southerners named Johnson. Andrew Johnson, who succeeded Lincoln, was born in 1808. Lyndon Johnson, who succeeded Kennedy, was born in 1908. John Wilkes Booth, who assassinated Lincoln, was born in 1893. Lee Harvey Oswald, who assassinated Kennedy... I'm sorry. What did I say? I inverted this. You're right. 1893. Okay, here we go. Then Yes, I am. I definitely am dyslexic. Yes. Okay. Anyway, it's 1839. Okay. Now, Lee Harvey Oswald, who assassinated Kennedy, was born in 1939. Okay. Both assassins were known by their 3 names. Both names were composed of 15 letters. Now hang on to your seats. Lincoln was shot in the theater named Ford. Kennedy was shot in a car called Lincoln, made by Ford. Lincoln was shot in a theater, and his assassin ran and hid in the warehouse. Kennedy was shot from a warehouse, and his assassin ran into a theater. Booth and Oswald were assassinated before their trial. And here's the kicker. The week before Lincoln was shot, he was in Monroe, Maryland. A week before Kennedy was shot, he was with Marilyn Monroe. Cheap shot, okay.
Okay, are there any more announcements?
I came across a great little book here. If anybody's interested, I will tell them what the name of it is, all of those in tape land. It's called Commercial and Debtor-Creditor Law. This is a 2001 edition, but the ISBN number is 1-58778-036-4. I'm sure there's updated one, but in this book, it's about 2,020 pages or so. It has the Uniform Commercial Code in it, including bankruptcy code procedures. I'll just read some of the stuff. Uniform Consumer Credit Code, Motor Vehicle Certification of Title and Anti-Theft Act, Federal Lien Registration Act. It has Uniform Computer Information Transactions Act, Truth in Lending, Federal Tax Lien Statutes, a whole bunch of very good information, especially the UCC code is in here, which also has the leases and the negotiable instruments. If anyone wants to take a look at this afterwards, they can. But I don't know what it costs, but it seems to be a textbook for course, which deals with banking and UCC transactions and the like. Anything in commerce. It's a commerce course book. So if anybody wants to take a look at it afterwards, or I can just pass it around and they can look at it. It's very useful.
Any more announcements?
I don't know about an announcement. I'm going to ask you, Jack, a good question here. On this paper you gave us last week,
which was a copy of that bond.
yeah. I got a question. Do you use this in conjunction with the appraised value? Or can you put that in here?
We'll probably talk maybe a little bit more about what was used pursuant to. It was used first in a case of a couple of guys out of Iowa that was in a federal case, and they went and put that bond in same morning that they were up for sentencing, and they went home. So we passed out a copy of a bond that come kind of from Elvick a couple of months ago, where when they denied the appearance bond, you accepted their denial, made them the accommodation party surety, but then you underwrote their liability on that bond with your signature, with your account. I would suggest probably strongly that this style of bond is better than doing that, because it's not creating the allegation of a charge against anybody for having done anything wrong. And we'll talk a little bit more about that bond tonight, along with some other things.
All right. You throw in also, if you get the ticket, and you put the appraised value on there, accepted.
Well, if you notice, there was no value per se on that bond.
That's what made me...
And part of the thing was they didn't even put an EIN number on their inclusion, but it was in their own case, in their own trial, so it was assumptive, presumptive. But I mean, there's a number of things they did not do with what they just up and put into that case, and yet the results were quite dramatic. And the guys have been on the internet talking about what they think is the results of what they did and why it happened. And we'll discuss some of those.
Okay. I'll leave the rest of the questions go until that.
Okay. Anything else anybody's got? Okay. Should have announced this last week. I apologize. Cindy and Byron Beers out in Mesa, Arizona are going to have a seminar or a weekend deal, at least on Saturday, June 14th, 2003, in Mesa, Arizona, 9 o'clock to noon and 1 o'clock to 5. It's $35 single, $50 husband and wife. The address is going to be at 3828 East Covina in Mesa, Arizona. It's about creditors and their bonds. And if you're interested in that, you may want to get in touch with them. Is there anything on here? They've got a bunch of hotels and stuff in the area you could stay at. Phone number is area code 480-654-3856. There's limited seating for 30 plus. They're talking about the fact that usually they have tapes available from what they do. So if you can't make it, or if it's after time and you're interested in the tape, you can give them a call and find out what's going on there too. And Cindy and Byron have tapes from a lot of other seminars or one-day things that they put on too. If you're interested, you can probably just contact them at that phone number and have them either email you or do something to get you what's available. They do a fantastic job of research and teaching, so I really recommend that. There's been some interesting things going on and happening out there. Last week I was going to talk about a letter that Winston Strout put out to a lady, and he was talking about some things, and I think I'm going to go over that as an introduction to where I want to go tonight. There is some really neat stuff about colorable pleadings and charging instruments in the courts and how we deal with those, the difference between courts of equity, courts of law, what goes on, who controls them, etc. Here's the introduction letter from Winston Strout, May 20th, 03, this year. He said to this lady, "Thanks for the articles. Yes, I think I understand some of that. Here is what I see. The acceptance for value is totally administrative in nature. You are exhausting your administrative remedy with it when you send it back for the settlement. But you are not giving the other party their administrative due process until you take the administrative remedy into a court for a judicial review to see if your process is correct." Now remember, I've been making comment that you need 2 witnesses for everything you do, one from public, one from private. The administrative procedures that we've all been learning and are encouraged to do is on the private side. And if they fail to respond or get into a dishonor, the certificate of protest comes out, notarial protest, which is evidence of their dishonor, which is really their agreement or capitulation to your issues that have been presented. However, that's on the private side, that's one judgment. And even though the notary public comes out and grants you the recognition of that process, that notary public is a witness from the public side, but it's still on a private proceedings. So what Winston Strout is saying here, this thing has got to be mirror imaged into the public and get a judicial acceptance of what it is that you've done in that administrative proceedings in order to be able to prevail at what you're doing. Now I'm going to leave this writing that I'm reading here for a second because I had a chat with one of my friends out in California this week, and he said that in his research something very interesting happened in the world in the year 1178 AD, which is perfectly relevant for today. Under King Henry II, they passed a law, a statute, creating the Curia Regis, the royal court. Up until 1178 AD, people settled their problems privately. Common law. After 1178 AD, and the king had this statute passed, the statute said that you are prohibited from settling disputes privately, and you must use the king's agents to resolve any disputes. That is in full force and effect today. It has never changed. So all of those happy patriots out there that are going around yelling and screaming, "We're sovereign and we have the right to do this and do that," may have been at one time, but everything that's going on in this court system dates back to the presumption of the Curia Regis, royal court, which says that you ain't got it until the king's court says you have. So if you want to argue that, dispute that, claim it's not so, go to war against the King's Court, i.e. the bar, whatever you want to do, have at it. I'm just giving you notice of what it appears to be in the law. Tell me where we're still not under the statutes of the King of England based on all of the bankruptcies, all of everything that's broken down, and the fact that we're not under English law. So you cannot settle your own case without the King's okay. Or what Winston Strout just said is, you can go ahead and you can do your private administrative all you want, that process, but until you take it back into the public court judicially for a review, you ain't got nothing yet. So we go back to Winston's letter. So let's say you are in a case and some, quote, charges, unquote, have been made which you have accepted for value and returned. If the other party does not adjust the account and give you the check, i.e. the order or the receipt for the bill of goods, then they are in dishonor. But what is the evidence of their dishonor? The court cannot see it. It is administrative, and you have not brought it in for judicial review. So you have to bring the dishonor before the court so that it can be noticed by the court. It would seem simple to file an amended complaint into the case or make the evidence and put it before the judge. Lee, isn't this what we were talking about in your friend's case? This is the guy who's got the kids and the wife that's drugged the kids out of state, and all statute law, all contracts of agreement in the divorce settlement say they can't do that. And this gentleman has been very honorable. He's done the private administrative procedure, and he's got evidence out the kazoo that this woman, his ex-wife, has taken the kids out of state without permission of state statutes, in violation thereof, and in violation of the court decree that she was a part to, which said you can't move basically more than 100 miles without the court's permission with the children. And she did that. And the best that this gentleman has been able to do by way of his private administrative proceedings and putting some things before that court is the court ruled that the ex-wife would not, could not, and does not get any alimony or does not get any child support for those children. Why isn't she getting any child support? Because she is in a dishonor. She's in violation of the contract, she's in violation of the state statutes, and the state won't be assistance for her to get any child support as long as she's in violation of the court orders and the state statutes. But above and beyond that, this guy is desperately seeking an order out of this court with teeth in it to bring those children back to him. And so far he has not got it, correct? Okay. So the problem is he's done private administrative procedure, and when he tries to bring this to this court dealing with family and children, the court says, okay, we'll take that under an advisement, and months go by and nothing happens. So the question is, A, did he do something wrong? B, is there something he hasn't done he needs to do? In category B, is it because he hasn't made evidence appear? Is it because he hasn't put the court in the capacity to hear the evidence? Whatever it is. That's what we're looking for. So in that case, it's important, and I'm going to tell you an example later on about two patriots and a public notary in a state that have been arrested and charged in felonies. And their problem is they can't make the court of equity see what they're doing. So that's what we're going to talk about and hopefully raise the bar of our understanding as to what's going on and how to get a remedy. Winston says, or you could call an evidentiary hearing and put it into evidence that way. In any event, You have to get the accepted for value presentment contract into the judge's evidence file and also enter the fact of the dishonor into the evidence file so that the judge, and then he says, forget minister, you get rid of the ministers in the public courts and you turn them into judges in the public courts, so that the judge can find the facts upon the examination of the evidence file and make a conclusion of law based on the contract he finds in the evidence file. See, now the judge can enforce the contract or the dishonor acceptance for value contract presentment. So, in brief, here's what he's looking for. Tell everybody what we're doing before we do it, and then we'll tell you, and then we'll remind you. You're either in a court of equity or you're in a court of law. The problem is that the public corporations are in a receivership. Being in a receivership, they've lost title to all property. Therefore, they can't have any property. Therefore, they can't have titles. Therefore, they can't even have contracts, because contracts deal with property through titles. So remember back in the mid-30s, the feds said in the Erie Railway case, the presumption is there is no federal common law. It's a presumption. It didn't say there wasn't any common law. It said the presumption was there was no federal common law, which tells you that all federal courts are presumed to be what? Equity. Now, if you have a contract between several parties, what is the law of that contract? What is the law of that contract? The agreement of the parties. That is a common law. Okay, now remember, on the private side, the Erie Railway case was not about private parties. It was about commercial things that impeded the public interest. So there's no general common law. There is private common law, and the private common law is the agreement of the parties. It's the contract. Contract law is the highest form of law. It supersedes all other law. Unless for some reason there is a law which prohibits certain things in a contract. Like it would prohibit a contract being valid in which Party A contracts with Party B to kill someone. That would be a void contract, an invalid contract. But ordinarily, if the contract deals with the subject matter which is not otherwise forbidden, it's the agreement of the parties are the law of the contract. So what Winston Stroud is talking about here, he's saying that what you've got to do is you've got to get this person that's acting as the referee in this court to act in the capacity of seeing a contract. If he will take judicial notice of a contract, is he going to rule in law or equity? He'll rule in law. If he doesn't take judicial notice of a contract, where is he going to be? He's presumed to be in equity, and he won't leave the presumption unless you rebut the presumption. Now, if you are capable of getting that party to take mandatory judicial notice of a contract, what is the purpose of putting the contract before this entity, which now would be a judge, not a minister? Get a remedy for what? For damages. How did the damages occur?
What do you get about your evidence?
Evidence of what? It takes a breach. The first thing it takes is a contract. then it takes a failure of a duty. Contracts put down benefits and duties on the parties. And if there is a breach of a duty by one of the parties, then there has been a breaking of the contract. Ordinarily, if someone has breached his duty, it creates a damage to the party to which that duty incurred some kind of a benefit. Once there is a breach in the duty, the party that's in breach is the debtor in that contract to the other party who is the creditor. Now that you've had a violation of the contract, you bring forth the contract first so that the judge will take mandatory judicial notice that there is an agreement of the parties, a contract. If you get him through that step, then you bring forth the evidence of the breach by the other party. If you now have the evidence of the contract before the court, and you have the evidence of the breach by way of rules of evidence that apply under all of the federal and state rules of evidence, then there must be an appraisal on the amount of damage, an assessment. And the way out of the problem is for the party in breach to accept the assessment so that once again you've got a new agreement now. The offer, this is the assessment for the damage. The acceptance by the party who was in breach. Now you've got a new contract or a new agreement whereby the judge can take mandatory judicial notice of that facts of agreement of the parties to offer a common law execution to carry them out in case the party who's in the breach that accepted the assessment does not carry it out for settlement and closure. That's a synopsis of everything we're doing. And it's all in law because it deals with contracts, which is absolutely opposite to everything that's going down in the public because they're doing presumably nothing in law, nothing in contracts. They're dealing in everything with equity. If you bring a law issue in front of an equity court, they will look at you like you're crazy. It will not register. They will not take mandatory judicial notice of it. They will not rule on it. They'll ignore it and keep going right by. And that's what's been happening. Our problem is none of us understand what it takes to turn a court of equity into a court of law so that what we're attempting to do in the redemption process can be seen by the court and any sense can be made out of it. We've been talking about the fact, I think I may have mentioned last week, that if you go into court with the LVIC 3 or 4 statements, that I accept it for value, I return it for value, do you have any claim against me? The court just looks at you. What is a claim? It's a law issue. And they're an equity court. There's no claim there. All there are is charges. So the judge nor anyone else answer that question. Do you know anyone who has a claim against me? Once again, no answer, no response on point. They're a court of equity. They don't see claims. I request you release the order of the court, the title to me. They're an equity court. They don't deal in execution of titles. So it's a case of you speaking law and them speaking equity. Now the good news is that they're supposed to wash their hands in law before moving to equity. And it appears as though you're fundamentally getting down to an issue of law, so you ought to be on top. The problem is in the background, they're holding an instrument or a document that's presumptively against you, where you move from law to equity. Therefore, they presume you've already washed your hands they can continue in equity. They don't need to have to wash their hands back in common law or in equity. You had common law to come over and reach you because it's assumed and presumed. You don't have standing in common law to do it. So if you say, well, there being no one that comes forth that has shown a claim, I'm leaving, sometimes they may let you leave and then they'll just go ahead with their equitable pursuit and put out an equity warrant for the arrest of the equitable character that's mentioned in their equitable charges. And sooner or later they'll come and drag you in again. Or the judge, seeing you walk out of the court knowing you're the proper person in equity and you haven't done anything to convert him, may order the bailiff or the marshals to grab you and detain you because you're in contempt of an equity court and they have done nothing to move that court from equity to law. That's what's happening. Strout goes on. I don't know if the authors of these articles, i.e. some that this woman sent him, understand anything about the judge's bond. If you give judicial notice of the judge's oath of office, either on paper or orally, and get the court to take judicial notice of the judge's oath of office, you have the judge under his bond now. And he is prepared at that point to get into a contract with you. Let's put it on the opposite side of the mirror. We know according to the statutes that all the judges are supposed to have oaths and bonds filed. Does an administrator need that judge's oath or bond to be filed? No. When you come into the proceeding, what does the officiant believe he's sitting under? Equity or law? Equity. Does he need an oath and a bond? No. So, many of them may not have filed oaths or have bonds. Who cares? Presumptively, they're sitting in equity. They don't need it. Why don't they need it in equity? Well, equity is a fiction. The difference between equity and law is very simple. In the law court, there are facts introduced pursuant to the rules of evidence. In an equity court, everything is assumptive and presumptive. If an official is going to rule in a case in which all the facts before him are assumptive and presumptive, is he operating judicially? No. All he has to use is his discretion to be fair. And in a world of illusion in which everything is assumptive and presumptive, that probably covers a large area, all that discretion there. In a case in law, the evidence is never submitted unless it's absolutely put before the court through a procedure and a process which follows the rules of evidence. Exactly. Which means it's done under oath, true, correct, complete, and certain, with first-hand knowledge, with only some exceptions under the rules of evidence for an exception under a hearsay rule. But the evidence in an equity court can come in any manner. Doesn't even have to be under testimony. Doesn't have to be pursuant to the rules of evidence. Because equity is a fiction. What are the rules for operating in a fiction? There are none. No laws and rules apply to fictions. When an equity court starts a criminal proceedings, they so-called have complaints, information, citations, indictments, etc. Ever seen any first-hand evidence by a damaged party in any one of those cases ever? No, they're not law cases, they're equity cases. They have no relationship, basically, to law. So we don't need a judge with an oath, and we don't need a judge with a bond. Now remember, we said that the public tribunals are colorable, and they can't handle black and white truth. So you can't go in there and say to the court, hey dude, I know you're sitting in equity, and I demand right now you sit in law. And the only thing we're going to do is bring in all the facts and evidence under the rules of procedure. Got that? He'll go, sit down, shut up, or I'll hold you in contempt. Why is he going to do that? Well, it may be too much truth, whereas his authority to do that to you. He's sitting in equity. He doesn't have to listen to your truth. Duh. You haven't converted him. So when you convert him, you got to do it colorably. You got to do it in such a way that the average one listening to this whole procedure and seeing it is not going to have a clue what's going on. You got to conceal it. He goes on here. I know the author of those articles understands something about judges' bonds. And so he said, if you basically request of the judge, will you take judicial notice, or do you have an oath of office? If the judge says yes, the next question is, will you take mandatory judicial notice of that oath of office for the proceedings in this matter? What have you just done? Requested that he move from equity to law. The judge can do one of two things. He can say yes, in which case if he's taken mandatory judicial notice that he's got an oath of office, whether in fact it's there or not, he's just said, I'm going to contract with you with regard to this matter. Oh, we're going to be in a contract court? What kind of a court is a contract court? Law court. You had to go the extra route of forcing the court into a contract to move it from the presumption of equity to law. If you failed to take that extra step, the presumption is that the judge will remain in equity. Yeah, let's say the judge says, no, I'm not going to take mandatory judicial notice of my oath. What are you going to do then? I accept that, Your Honor. Can we have an adjournment till next week or something? What are you going to do? You're going to go out and you're going to get a certified copy of his oath of office, aren't you? What are you going to do with it? File it into the court proceedings. What authority do you have to file it publicly in the court proceedings? His dishonor. Don't do it before he dishonors you. That's not honorable. But you're not going to argue with him. He's going to see if you understand how to honorably resolve this impasse. Now that you have the judge sitting in law, what had you better do? Law pleadings. If you go back to equitable pleadings and procedure, what have you just done? cancel the law court, putting him back into equity. For those that have eyes to see, let them see and do it. For those that do not, they're going to screw it up. He's probably going to test you to see if you will leave law and go back to equity to relieve him of the duty of judging the matter in law judicially under a bond and oath. So it's not just your procedure of how you're dealing with your opponent. It's not just the honor of being on the substance side of the proceedings. You've got to know the difference between a law court and an equity court, and what makes one a law court and what makes one an equity court. Otherwise, you bring in all your good material, you throw it in front of the judge, and you ask him to take mandatory judicial notice, and he does what? Well, I'll take this under advisement or into consideration. And then you never hear from him again. Didn't rule. I don't know if the authors understand that. See, a minister cannot see facts. And he cannot see the law contract. And hence, when you ask for findings of fact and conclusions of law from a minister, they cannot find any facts and they cannot make judicial determinations on the contract law. For one thing, because they don't have a public hazard bond to make judicial determinations. It is not in their scope of office. If they tried to do it on their own without a bond, they'd be privately liable. You would have to indemnify and hold harmless a minister before they could do any such thing. Now keep in mind partially about the bond document that Bob raised the question about at the beginning of the meeting. Is it possible that the bond that is put in there is providing the surety for the public administrator so that he has some form of indemnification if he takes mandatory judicial notice of the contract in law and the breach of the contract and rules with a law decision? If the judge acts under his oath of office, he is bonded by the people. And subject matter jurisdiction lies without any other bonds. It becomes a court of original and general jurisdiction. And the judge can hear the matter without any other bonds. Remember, we said in a court of equity, you had to put a bond in there in order to invoke the jurisdiction. The voice of the people is the bond. Quote, Your Honor, for and on the record, have you sworn an oath of office? Unquote. Answer, yes. Quote, Will this court take judicial notice of the oath of office of John Smith? Unquote. That being the name of the judge. Yes. Now you have a judicial court which is all bonded up unless they are bound to the law and the contract that you are bringing in for execution. At that point, the judge cannot see the fiction. What are the fictions? The assumptions and presumptions of equity. If he attempts to recognize a fiction, he is in violation of his oath and he forfeits his bond. You cannot let him run back into fiction or equity, or you have lost your jurisdiction over the contract. And subject matter jurisdiction goes back into assumption. Now you are in complete control of the case, if you put it in law, and you are the plaintiff moving party, irregardless of where you stood on the caption of the case. The phrase, my word is my bond, and you can take all the paper fiction to the incinerator. Your Honor, will you look in the file and find the facts and make a judicial determination on the law? Is there any general public law? No. They're all in receivership. That's an illusion and a fiction too. So where is the only real law? Between the private parties, the agreement of the private parties. So when you get the court to act in law, you're getting the public minister to go judicial to officially see the acts of the private parties. Is that what you need to do to get a ruling in? That is the sum of the whole thing. The facts are the agreement of the parties. And the agreement of the parties is the law of the contract. Now the judge can execute the contract and you can have your judgment. Now and only now have you given the other party their administrative due process. The judge looks at your acceptance for value private contract with the certificate of protest evidencing the breach or dishonor. He looks at the agreement of the parties, perhaps estoppeled by silence, etc., i.e. notary certificate of non-response. He assesses court costs, his salary for his time, and pays the rent and the light bills, and writes you a check on whatever is left over, business as usual. He gives you your judgment. This is not complicated. Now that is the easy way. The other way is to put in a surety bond to indemnify the judge under contract and just take off where I have the court take judicial notice of the oath of office, etc., and you're doing the same thing. But see, whoever brings subject matter jurisdiction is the plaintiff in fact, or the super above plaintiff, and he is the moving party. The judge is working for whoever pays or bonds him. Now, which pleading ordinarily in a court is filed first? The plaintiff. Does that give the court subject matter jurisdiction under equity? No, because it's an offer to the offender or the offendant. He's the creditor. He gets to respond and choose the subject matter jurisdiction. He's the one that determines whether the court is in equity or law. If he screws up, it stays in equity. Doesn't that make sense? So he said, whoever brings subject matter jurisdiction. Subject matter jurisdiction, like he said, is who's going to pay the judge or who's going to bond the judge. In order for it to be a law court, the people have to bond the judge. The people bond the judge if they follow the rules of evidence and procedure, right? Do the equity courts ever follow the rules of evidence and procedure? No. So if you respond to the plaintiff, and he's the leader in the dance, you're off in no man's land in a fiction. The judge doesn't need a bond. He's a minister under discretion to sort out all the illusions to give us a happy ending. But nothing relating to the contract or the agreement of the parties and the actual facts in the case. They're all irrelevant. Didn't we tell you a couple of months ago that in the equity court, anything in a box isn't there? Didn't we agree the jury's in a box, so they're not there? Didn't we agree that the witness is in a box and the witness isn't there? So in an equity court, any facts that come out of the witness's mouth is irrelevant. It just interferes with our assumptions, presumptions, and illusions. And we can't have that in equity. See, I've been telling you this all along. We haven't been getting it. If the state bonds the judge, then the state gets its way. Didn't we say that if you're in a criminal case and you presumably go on the defendant's bond, that the defendant's bond is a liability instrument, therefore the public holds title, therefore the case is prosecuted under public policy, which is equity, which is presumptions, assumptions, and illusions. How does one have to go about getting control of the case? Accept all the offers for value without argument, request a bond be issued without public charges, costs, expenses, so that you may be at liberty through that bond, i.e. if there's no, quote, money to pay for that bond, then where does the commercial energy for that bond come from? The word of the bond maker. And isn't he a living soul? And isn't his energy real? So the real energy backing his bond with his word is not a liability instrument, it's an asset instrument. So he controls the title to that ORPR bond. Therefore, it's bonded privately, not publicly. Who's the creditor in the case? He is. Which means now the judge can act in law unless the idiot reverts back into equity. If he reverts back into equity again, he's just donated his private bond for public purposes, and he's prosecuted under public policy, the equitable illusion. See how this goes? Comment or question?
The way I understand this, correct me if I'm wrong, the bond is the person who issues the bond is the creditor.
Right.
So it's like preferred stock? Like
the true holder, the true party who's liable for the surety of the bond is the creditor.
Well, it's insurance. The bond is the...
That's all it is insurance. But what I'm saying is if the public says, here, sign this bail bond and go home, you put your name on it and go home, it's not your bond.
No.
If you had to pay them something for it, or if they're going to take that bond and register it in the court record books and charge you a liability fee for the registration of that bond. That's why you've got to get them to issue the bond without fees.
So if you put a bond before you go, and the bond is that you issued it, you're actually pretty much in control as long as you don't go into equity.
Hang on. If you go in and just throw a bond into the court, what have you done? It's a dishonor. Why is it a dishonor? It's a presumption that they won't be honorable and give you the bond. You can't put a bond into the court unless they've denied you the bond.
You cannot put your own bond before the court before you...
Not until you've asked them to issue you the bond. Otherwise, you're in dishonor. That's why you come in and ask. They can only say yes or no. If they say yes, we're off and running in law if you can keep it. If they say no, you accept that. Now what do? You go down and put the bond in, ex parte, based on their dishonor. And that's the bond that Bob had in his hand, and similar to what we passed out last week.
Okay, the question then I have something on the bonds. When the judge issues a bond in the equitable court, publicly for the record, he's creating a bond, or is he using some other...
Remember, what Winston just said is if the court is in law, who bonds it? The people. So do we need any bond? No. If the judge says you've got to provide a bond if you want to go home, what have you just been told? We're in equity. This obviously is not a court of law, Dorothy. You're not in Kansas anymore. You're in the corporation. So now your job is to turn the court of equity into a court of law before you attempt to negotiate any contracts or put in any evidence. Otherwise, you're just wasting your time. Yes, Lee.
And procedure-wise, I'm just sort of relating back to the fellow with the children out of state. He has come forward and petitioned the court to take judicial notice for an order of the court to have the children returned back to the state and to join their siblings. And what I'm having trouble with, if he's done that, he has petitioned the court to take judicial notice, and he's entered the exhibit to the court of the contracts. Hasn't that moved the court at that time? Or has there not been an agreement of the court for a court of law?
Did he put a bond in? Is that what you were saying?
No, he just put a petition. He put a petition in for the judge to take judicial notice for an order of the court, and he provided the order of the court.
Did he do anything with the oath? Judge's oath?
The first time around, he took a petition. He brought the oath in as an exhibit. He made it as an exhibit.
Did he ever ask the court to take mandatory judicial notice?
Only in the petition. He says, I petitioned the court for judicial notice for an order of the court.
And the court never responded to that?
They had the hearing, and they accepted all the evidence, but the court then stood up.
Well, they received the evidence. Did he ask that they admit the evidence into the file of the case? Because, see, taking notice of evidence is separate from then requesting that the court put the evidence into the file. First you introduce it. Hello, this is evidence exhibit A. And they go, oh, cool, yeah, I see A. But it's still sitting on the private side of the file.
He sent a request to the court to admit all evidence into the hearing.
If you go down to that court file, is all that evidence
sitting
on the public side?
It's on the public side.
Okay.
He has taken they listed all the private side evidence, letters rogatory, all that, and he asked for those to be moved over, and he's noticed they were. They're now in the file.
There must be something about the fact that that judge still is not sitting there in law.
No, and he made a request to the court to have an interview with the legal department, and they said they have no legal department. And they sent him over to the prosecutor, and the prosecutor did everything they could to get rid of him by saying, that's a domestic situation. We only handle criminal cases here. Get out of here. And so, he's not exactly he's not going to stand there and argue.
Yeah, I understand.
And so he said, okay, that's the best I can do. But the clerks say, well, no, we don't have any attorneys here working for the court. We don't have anybody to give to show procedure. We don't have any legal department. You must be thinking of some other kind of court. So the words, and we're using the correct words at request, but he was denied, and they claimed to be, could not understand what he was saying. But he has tried through petition to take judicial notice.
Okay, this is a family court issue too. The next issue is has he filed all the UCCs on his kids and himself?
No, he has not.
So then it truly is just slaves of the state.
That's correct.
So there is no issue of law. It's just slave policy going on here. And so how could he convert a court into law?
Yeah, he still has to do that because there is still violation of the contract and of the statutes of the state going on, and the court will not take action when they're requested to take judicial notice. Had the statute brought in and had the contracts brought in, highlighted, and brought in and made evidence
And the
by the
best,
clerk of the court.
the best he's gotten is he's not paying child support to the
That's
woman
what
who's
the
in
order came out.
violation of all of the
Yes.
orders. So what the court is literally doing is contempting the wife by not abiding to the contracts. And then they merely tell both parties, go out and get an agreement. So get a new contract.
And the judge put in there, after taking away child support for the two children, the judge also put in another statement saying, I suggest you work out a visitation schedule for parenting. Not in order. They already have an existing schedule or a parenting time under shared parenting. And all of a sudden, he did not say that it did not exist, the existing one. He just put a suggestion. His words were, I suggest. Not an order.
Get another one.
That you should, and then this,
Get another agreement.
the mother of the two children that she's taken out of state has been attempting all the time to get another contract going, and the father is saying, no, we only have the original contract.
Well, what the judge is probably saying is he has it perfected as evidence for the court, the breach of the first contract.
It's brought in as an exhibit, and it was shown every element of it that was in breach.
What is the evidence of the breach? He brought the contract in. Where's the evidence of the breach? What did he do there?
Then he brought in all his letters of advice, dishonor, and his certificates of dishonor showing that there was, and her letters indicating that her attempt to renegotiate a contract that was already in existence. They already had a signed contract for parenting.
Did he give her the ability to show cause why the original agreement isn't the best and the only agreement that they should
That's
do?
correct. Every single time when he had accepted her letter and returned, he said, show your authority and show where the original contract is not in the best interest of the children.
Okay, let's play another game. He wants her to come back or bring the kids back within the 100 miles. Maybe what the judge is waiting for is to turn the case from equity to law, just like Solomon did.
Yes.
Who is the party that's willing to sacrifice to see the kids? And the guy that keeps saying, well, you got to bring them back to this state. Well, isn't that easy for him? What would happen if, what has she been asking for that he keeps saying, but show why the original? Has she been asking for, well, you can come and get them on the weekend anytime you want as long as you come all the way to Timbuktu? Is that what she's saying?
You could say it that way, as long as the agreement of the parenting time for the children is within her parameter as to what she deems is essential.
Have him play this game. He's going to do a sacrifice.
Mm-hmm.
I accept that. Have the children ready in Timbuktu next Wednesday. Now the problem is equity, if that's where she wants to stay, requires that he come and pick them up and she comes and gets them. So I accept that. I'll come and pick them up, hold them for 3 days, and then you come and get them. See where she goes on that one. What do you think she's going to do on that one?
As she has done in the past.
Absolutely dishonor. Right. You can come to Timbuktu, but you got to bring them back to Timbuktu.
No.
Excuse me, that's not equity.
Yeah, she'll dishonor by the fact that she won't be there in Timbuktu.
Great.
She's going to be down in Miami Beach, where she's headed
Absolutely.
right now.
Then where is the level of sacrifice and the dishonor to the new contract? if you're unwilling to sacrifice, you're not going to change the court of equity into a court of law. Because here it appears as though everybody's asking for everybody's asking for the baby. I want the baby and I want it in my house. No, I want the baby and I want it in my house. Well, you can't have the baby in your house. I have the baby in my house under law. Okay? Well, okay, then I'll come and get the baby for 3 weeks and you come and pick it up. See, now the problem irons itself out. Because, see, this court is going, well, she's out of our jurisdiction. But if the guy gets an agreement to have child visitation and the kid comes back into town, what's good for the goose in equity is good for the gander. If he had to go to Timbuktu to get the kid and bring it back here, and then she won't come here to pick up the kid and take it home, then obviously she's the problem, not him.
But there already is a contractual agreement between these parents as to the best interest of the children.
I understand, but the court's sitting in equity. And the court is seeing a fight between a husband and wife as I want the baby at my house. Well, she could try to negotiate the contract, so she moved out of town. As far as the court is concerned, maybe that's what she decided she had to do. But if she decided she had to do that, then in equity, she's got to pay the price of what she decided to do. Court can't keep her from moving. It's her life. But he's got a right to see the kids. And if he'll go to Timbuktu and pick it up under the new agreement because he's willing to sacrifice, she better come from Timbuktu here to pick up the kid and take it home. That's what she's looking for, equity. She doesn't want the law. Okay, ladies, so you're working on equity. And the judge goes, well, let's try equity and see if it works. So just try to make an agreement. The judge didn't say duty impossible. He just said go out and make an agreement. Now, when you go out and make an agreement, in order to be an honor, you got to accept the offer. And she said, well, come on over here and get the kids. Or whatever. Okay, fine, but I'm going to take them back home to my house and enjoy some time with them. Then you come and pick them up. That's equity. If that's what she wants, give her equity. And when she dishonors the equity, then at that stage of the job, the judge goes from, well, she dishonored equity and I've been moved into law by the one who would sacrifice. Therefore, I'm going to issue the law decree.
The sacrifice was already at the beginning when the father no longer had any contact with the children.
That's because she breached the contract. Yeah.
Right. And you're saying
that wasn't a sacrifice because on his part he didn't have anything to do. He was the victim. That wasn't a sacrifice. It was just a breach of the contract.
I think
he
I'm
was
trying
a
to
victim in the
avoid
breach.
a second contract that would nullify the first original contract, which was in the best interest of the children.
Well, hang on. Look, the original contract was in the best interest of the children. What he's trying to find out is which one of the two parents is dishonorable. He could assume and presume it was circumstance that the wife had to move for whatever reason. Health, job, support, family, whatever it is. But why she had to move does not necessarily impinge why the children have to be there with her.
Well, she had that hearing and received no judgment from the court as giving her authority to move.
I understand. She just up and did it, ex parte.
After the hearing.
Yeah, it was a dishonor.
Yes.
Okay, but then the key issue here is whether or not the husband is going to be willing to sacrifice, or whether he's just playing the equity game of, I want the whole baby, no, I want the whole baby, no, I want the whole baby, no, I want the whole baby. It's an exact duplicate of Solomon and the two women. Instead of the women fighting over whose baby it really is by birth, you have the husband and wife fighting over which parent wants to have custody in which location for right now. It's the same thing. And the court is perfectly setting an equity. Obviously, the court's never appeared to see the contracts in law. It's just saying, go out and make a new agreement. Well, face it, an agreement is law. But this new agreement will be under the order of this court. And if she screws up this new agreement, she's in dishonor to this court that's issuing the orders.
It was this court that did the original contract. And then there was a modification of the original contract that eliminated child support according to the order of the court for some unknown reason. There wasn't a reason given. It's just that the child support will be discontinued.
To her.
To her.
That was dishonor on her part.
To the
violating the
right.
first.
And then the suggestion was for the parents to work out a parenting plan.
Yeah.
When there was already a parenting plan in the original contract, or the original decree that the court, that identical judge, had just completed a few years earlier. So it wasn't like a different court. It was in the same
court. Different court. Judge probably.
Nope, same court. Same judge.
Same judge even?
Same signature.
Wow.
Nothing has changed. He has done the original decree, the modification where he said, I suggest, where he already gave a strict requirement of the parents to continue their parenting. And then he stands back and says, I will take this into advisement.
But he hasn't issued any execution, and it's
No.
been, over 4 or 5 months now, or longer?
Well, let's say simply, it happened in August of last year, and a new petition was put in for judicial notice in about January.
So we're 10 months.
And then the court came back, the scheduler came back and said, we are not returning this petition to you, but it is already pending. The conditions are already pending since August. And the judge has not rendered a decision. So he's sitting there acknowledging the fact that there was a petition to take judicial notice for an order. The order's sitting there.
What would happen if the guy would petition her to share custody, like on an equal time in each location? What do you think she's going to do?
I can't speculate at all on that,
because it's theoretically
there hasn't been a consistent behavior pattern that I could attach to as the observer. Every single hearing I observed in letter rogatory, I sent letter rogatories to the administrative judges to take the notice of the fact that this is still a lingering decision. And there was no
Let's think
response.
about this for a while again. I know this
Yes.
has been a real problem, but I noticed that we're getting Caleb so upset he's cutting up cans with knives, and I fear if we get him any more wild about this, he's going to do injury to himself right now.
He's a nervous man.
He really is.
He's a nervous man.
I mean, knowing how he gets so upset with the courts and everything anyway, I can see that.
The truth will not set him free.
Well, it might, but it's going to take a while.
I do believe we need to put our heads together a little bit
Yeah.
on this, because I haven't been able to even get the court to admit to, and I do know the names of the attorneys in their law office because I had already exchanged documents with them, concerning my own
Well, the incredible
appearance.
nature of this is this guy's got a good rapport with the court. He's been handling everything himself.
They're so happy to see him, and they're so upset that they haven't been able to get closure.
Yeah, and so there's got to be a missing link here or something or other, something we're not empowering them to do, or he's he's remaining in an argument or in an equity thing, not taking them to law. That's why we're kind of studying what we are today, because
Yes.
I think this is kind of moving us more in the direction of seeing the nuances of how this process works. And I know, like you said, Lee, we've been talking about this case all over the last 10 months, and it's just a real stickler.
Financially, he's not.
Hadn't got a problem because he's an honor.
But unfortunately, he has 3 children, 2 of which are wandering
with
about
him.
the United States,
Yeah.
and nobody really knows now where they are because she no longer has employment, and her husband, who she gave a public notice of, is a large man, lifts weights, loud-voiced, and drinks. That was her public testimony of the description of her new husband.
So he's a gem.
So he's, and he follows her without employment also. So last time we found out that they were just simply had sold a trailer. They're living in a townhouse, but that address doesn't exist any longer. So even family services have lost track of where they could possibly be. And the judge, who has been given that information through family services, is still sitting there and saying, and now he has put the clerks requested, and he did it. He put a summons for them to be brought into court. He says, please fill this out. So he filled it all out. And for them, so that the judge can sign it and have them brought in. The judge hasn't signed that, and the clerk doesn't understand. So we can't even get that signed by the judge. To have the parties brought into court to find out what is going on here in the best interest of the children. And so they
Has
thought that
he
was
ever tried to get child support for the child he's got?
Oh, he gets regularly.
And she keeps sending that?
She keeps sending it.
So she's not in dishonor there,
Oh,
so you
no.
can't have her picked up as a deadbeat mom.
No, it's not. It's not in fair proportion that what it was calculated, but it was a number at least that's it's. He said it's adequate, but it's not in proportion to what the incomes were. I mean, they didn't even go by. Well, everybody knows that calculation schedules are the calculation schedules, but he has support from support enforcement, the whole works, everybody. He has been 100% out in the open. He gives, when a letter of advice goes out, certificate of service includes the court and includes the referees, it includes every esquire and every esquire at support enforcement. And they're all understanding what's happening here, but the court, the judge, says he doesn't have room to move on this. And it'll be a year pretty soon, and he says it's pending now. It's still pending to be decided upon.
The judge's new girlfriend.
Yeah. So, yeah, I think we need to still, because I have run out of room as to all the procedures that I have. I just received a wonderful telephone call from somebody who said, the procedures that I had used and you helped me through, I have my freedom.
Mm-hmm.
He got totally released. The court did not want those certificates of dishonor brought in under judicial notice, and they just said, "We will. What is it we can do for you?"
This was a guy that was on probation?
Yeah, that's right.
And
Totally
he was
free.
sweating that he was going to go back to jail.
Go back to jail, and
the whole bit.
I felt like the minister working with him, trying to.
He had like 2
solve
or
him.
3 years of probation.
Oh, he
and
was like
some fines and
Oh,
stuff, and
it
he was
was-
going, "Don't rock the boat, or
Yes.
you're going back to jail."
Oh, the probation officer was just killing him, and plus
Mm-hmm.
messing up his jobs, I understand, and making calls and, checking on him. Of course, then your employer goes, "What?"
And you told him to request that they suspend the probation, and he was absolutely worried that
Yeah.
was going to get him back
Yes.
in jail too. Oh, I can't do that. They're going to put
I
me in
said,
jail.
you don't, you don't get half the enchilada. You get the whole thing.
Nothing ventured, nothing.
And he did it, and he called. He couldn't believe. He says, he made a mistake because they bargained with him and he paid some money, but that's because of the little pressure. But he said the money means nothing compared to the freedom.
Yep.
The small amount he paid, he's off. From now on, he can do whatever he wants, go wherever he wants. He was listing all the things he can do now that he was forbidden to do under probational and under tracking and all this.
Mm-hmm.
And I felt a lot of joy for the person because he seems to be the type of individual who's going to go out and try to help others by explaining the process and by getting involved with some education. So,
Yeah.
but I told him at the same time, I wish I could get these poor 2 children
Sure.
that kind of freedom.
Okay,
Because
we'll keep thinking about that. We're going to get the answer to it in the right time.
It's a
Father will give us the answer when it's necessary.
Yes.
I know. But thanks. Yeah, Jim.
I was going to say, how about a performance bond on what the judge requested and what the judge was wanting to do if he had a performance bond?
Well, that
on the
might
right?
be some of it, dealing with the bond, like we said, that if the judge won't go to law, maybe you can bond him through your private bond to do that. But see, this particular guy isn't under the UCC or anything yet to even recognize to be able to use his exemption per se to do that.
Couldn't he get a performance bond on his wife to do what the judge
Oh, if you buy it
requested?
in liability, you're under public policy. That isn't going to work.
Well, you would be financially covered if you bought the bond against your wife.
Yeah, I understand, but it's still under public policy. So you're still in equity, and that's what this court's doing. It's doing everything in equity. We got to move it in law so it sees the contract. That's what we're trying to do. And I'm just concerned that, a lot of us that have done the UCC sometimes think that means nothing, or that you don't have to do the UCC and you should be able to get the same results whether you've done it or not. And I don't, why is that process out there if it really means nothing? And this guy here has not done that process, so he's not standing in the capacity of being in control of his own life. He hasn't done it on the children. He isn't in control of them. So the children and he and his wife are all under public policy, which is equity.
Can he ask the judge for a performance bond at no cost to himself, that the wife respond to what the judge has already requested?
But what I'm saying to you is without the UCC, without taking that extra step, can't do it.
So that would mean if, I'm not a UCC guy, I can't do it either? Anything?
Not in that capacity of being on the asset side, because you haven't taken the extra step to get out. I'm going to talk about that in another context in a minute and show you what's going on here in the courts. Okay? Now, I got thinking about these courts and all of these pleadings. Look at the criminal pleadings that come against you. In a charging instrument, I don't care what it is, citation, complaint, information, indictment, whatever the heck they call it. Let's assume 2 things. Let's assume the facts in the charging instrument are all true. Let's assume that the charges are conclusions of law and that there are no direct facts linking you from the event to what you're charged with under the conclusion of law. We'll call this charging instrument colorable. What does colorable mean? It means that it's a little bit country, a little bit rock and roll. It's a little bit substance, it's a little bit fiction. The facts are what? Substance. They're true. They're in law. All the facts in the charging instrument are law facts. They're all true. They cannot be disputed. All the assumptions of the crime are fictitious. They're assumed and presumed they're in equity. So a typical charging instrument in civil or criminal is written to contain true facts, which means it's a law pleading, or assumption and presumption of what it is you did wrong, which is equitable. So the charging instrument that comes from the plaintiff to the offender is a combination, it's a colorable charging instrument that's a combination of law and equity. if my assumptions that I gave you, the facts are all true, and the charges are all presumptive because there's no direct link in facts, if that's true, don't you agree that all the charging instruments are a combination of equity and law? Okay? Now, remember, whoever draws the charging instrument, the drawer, he's what? The debtor or the creditor? The debtor. Which means that you are the one it's served upon, and you're the one that's supposed to take care of it, so you're the drawee. Are you the creditor or the debtor? Creditor. So they're honoring you by giving you this charging instrument that's a little bit law and a little bit equity. Has the drawer determined what the subject matter jurisdiction of this court's going to be? No, because it could go law and it could go equity, right? Because his pleading is a little bit of each. Who gets to decide what the jurisdiction of the court's going to be? The offender, the creditor. How does he elect whether he wants it to be a court of law or a court of equity? It depends on how he responds to the charging instrument that's a little bit of law and a little bit of equity. Let's play this game. In the charging instrument, the facts are law. Do you want to argue the law? The facts are all true. The charges in the crime are presumptive in their equity. Do you want to argue those? Do you want those presumptions to stand? Let's put it that way. You don't want the equity part of the pleading to stand. You want the law part of the pleading to stand. If you argue the law side of the pleading, you're an idiot. It moves to equity. If you disagree with the equity side of the pleading, the conclusion of law, you're standing solidly behind the law, the case goes to law. When you come into a pleading that's against you and you argue the facts, you're creating a dishonor to a law court, and the court sits in equity, which is an illusion. If it's a criminal case and you plead not guilty, what does a not guilty plea mean? You're disagreeing with the facts. The facts are all true. It's the law. So if you plead not guilty, what have you just done? You're arguing with reality, so the case moves according to your wishes to illusion. And we sit in equity. If you plead guilty to the facts, remember we were talking about the confession and avoidance plea in common law? If you do a confession, you're saying all the facts are true. With the avoidance, you add extra facts which rebut the assumptions and presumptions in the pleading. And if you do a confession and avoidance, where have you taken the court? To law, because you've disputed the false assumptions in their conclusions of law. So in a criminal case, by pleading guilty, it's a law case, and you can get your evidence in. By pleading not guilty, it's an equity case. Forget the evidence, it's on the moon. We're in an illusion. Does that make sense? Do you see what they've done to you? It's a little bit country, a little bit rock and roll. It's a little bit law, a little bit equity. What do you want on your plate today? You decide. You're the creditor. Now, they've taught everybody to plead not guilty so that they can move all these proceedings into equity, so that the true facts never get introduced to the court. If you plead not guilty, have you ever gone into a trial against a motion in limine that says basically you can't put the true evidence into the case? You ever won the motion against the motion in limine? Never. Because the facts are on the moon. Because you're an idiot, you're disputing reality. See what they've done to you? Now, well, yeah, it's like bait and switch. Now, here's what happens. Remember, since 1933, the presumption is the court's in equity. Which means since 1933, the administrator, i.e. the guy you thought was the judge, he is in equity too. Which means he's an administrator. He doesn't require an oath. He doesn't require a bond. He sits in discretion, basically judging just like the world of Alice in Wonderland or the Kingdom of Oz. Anything can go on here, and it all meets the rules, which are there is no rules in equity. So you have the courts presumed to sit in equity, the administrator is presumed to be in equity, and the counselors for the parties are presumed in equity. Now, once they hit you with one of these colorable pleadings, your job is first of all to put in a proper responsive pleading to change the presumption that it's going to continue as a court of equity, to move it into law so that we can produce the contracts, the brief